If you are an adult Muslim, you should have a will. The Prophet ﷺ said in a well-known hadith, ما حق امرئ مسلم له شيء يوصي فيه يبيت ليلتين إلا ووصيته مكتوبة عنده. It is not befitting for a Muslim who has something to will to let 2 nights pass without having their will written and kept ready with them. You probably already know, though, that you should have a will. In fact, 83% of Canadians think that having a will and an estate plan is important. And despite most of us knowing that this is an important thing to do, very few of us actually do. The data shows that only 15% of Canadians have a full will and estate plan. So this presentation is for you if you want to get your will done on your own, or if you are working with a professional and you want to have better conversations with the lawyers, accountants, and scholars who are helping you, this presentation is for you. Or if you already have a will and you want to make sure that you have everything you need in your full estate plan, then this presentation is also for you. This presentation is made for Canadians, but if you are in the US or in the UK or in Australia, you'll find lots of parallels for your situation as a Muslim living in a Western jurisdiction. So if you're one of the many who do not have a will, I think it's important to just think about why that might be the case. I think wills are generally out of sight and out of mind. We don't think about wills unless we're brought to remember them, maybe because we hear about someone's story about them passing away without a will, without a plan, leaving their family with a big mess, families fracturing as a result, and we think to ourselves, that's a sad story. We don't want to fall in the same traps. We don't want to make the same mistakes. So we make an intention to write a will. And then we begin to search online. Maybe we ask around a little bit, but we feel a little overwhelmed by the amount of information out there, maybe by the legal jargon that's used, maybe because there's not enough specific information for our unique circumstances. And eventually, if we don't act on it quickly, it ends up being out of sight and out of mind again. And this is what I call the will-less cycle. And this is something that we're trying to break. We want to break out of the will-less cycle. We want to have a will and later on what we'll call a legacy plan. And there's a toolkit that's for free that you can use to get that done yourself on your own. We're going to talk more about what's included in that toolkit later on in this video. But before we get there, we need to talk about some overarching concepts. This can feel like a little bit of a detour because it can feel like we're getting somewhat theoretical, but I need you to stick with me, because if we can have a common knowledge and common vocabulary, we'll be able to produce our own Islamic will and legacy plan that's comprehensive and cohesive. This begins with us thinking about what will preparation is. Will preparation is preparing for death. And preparing for death is not something that we are naturally inclined to do, perhaps, but it is something that the Prophet ﷺ encouraged us to do regularly. The Prophet ﷺ said, أَكْثِرُوا ذِكْرَ هَذِمِ اللَّذَّاتِ الْمَوْتِ. Frequently remember the destroyer of pleasures, i.e. frequently remember death. Preparing a will is not just going through a checklist of preparing legal documents. It's in fact an opportunity for us to engage in a very significant spiritual exercise and for us to hold many noble intentions along the way. Some of those intentions might include to remind ourselves that this world is temporary and our material possessions will leave us, but our actions will stay with us. We can intend to ensure that our wealth is distributed in accordance with Quranic guidelines. We can intend to promote justice and prevent dispute amongst our family members. We can intend to make things easier for those who we leave behind by clarifying our wishes and responsibilities. We can intend to fulfill our responsibility as parents, if we happen to be parents, by appointing a guardian who will raise our children to be righteous and mindful of God. We can intend to leave behind a legacy that inspires good deeds and strengthens faith amongst our families and communities. When we fill our hearts with noble intentions, this somewhat difficult task turns into an opportunity, a spiritual opportunity for us to grow closer to Allah subhanahu wa ta'ala. Now, I've spent the last several months listening to how Muslim scholars and lawyers talk about will preparation, and there's a lot of good work that's already been done in this space. But one thing that I've noticed is that both lawyers and scholars will focus on the legal compliance of the documents and the plan that's being produced. Muslim scholars will focus on ensuring that the plan that is being produced is calibrated to match the Quranic injunctions around inheritance, and lawyers will focus on ensuring that whatever your wishes might be are legally enforceable in the province that you live in. Now, legal compliance is very important, but it's just one piece of a bigger picture. A will may be legally valid, but relationally destructive if heirs feel blindsided, if there are lots of surprises. We certainly want a plan that satisfies provincial laws and adheres to Islamic inheritance rules, a plan that has clear documentation of debts and assets, but we also want to make sure that our plan is emotionally connected. We want to make sure that we have transparent discussions that explain our intentions and values. We want to make sure that we've found ways to build in mediation and conflict prevention into our plan. And we also want to make sure that our plan is spiritually anchored. We want to address religious obligations such as unpaid zakat or maybe unperformed hajj. We want to include an ethical will or a legacy letter to ensure that we are conveying personal wisdom that we've gathered along the way in our life. These three components are what we call the Islamic will and legacy plan. So here we are today preparing for our eventual end in hopes that we are buried as Muslims and that whatever we have on this earth is distributed in ways that are pleasing to Allah subhanahu wa ta'ala, and that after all is said and done, there's family unity. Now, we're not going to be around to see any of that happen, but there's lots that we can do today to make that a more likely possibility. All right, before we get into the practical side of things, we need to do a quick crash course on inheritance. And we need to do it from two different legal traditions. The first is the Western estate, what I call the two-tier distribution. So in Canada, everything that you own after death is split into two asset groups. The legal terms for this are non-probate assets and probate assets. Now, the way that I think about this is flowing assets and frozen assets. Flowing assets are things like your home that you co-own with your spouse, any joint assets that you have, any tax-advantaged investment accounts like an RRSP, a TFSA, etc. Those assets are flowing assets. They flow directly to whoever is listed as the beneficiary or to the co-owner, and they bypass the will entirely. On the other hand, frozen assets are those assets you might own individually. Maybe there's personal property, maybe there's something that you own with only you on the title, or if there's any taxable investments, those are frozen assets, and those require a will to be unlocked because they're frozen after death and distributed. The Islamic estate is somewhat different. The Islamic estate is what I call the four-stage distribution. The first thing that needs to happen after a Muslim passes away is to determine everything that was owned. And when you calculate everything that is owned, you have determined the gross estate, what is known in Arabic as a tarika. Thereafter, you need to deduct from the gross estate, the tarika, the cost of burial and debts. And after that has been deducted from the gross estate, you are left with what's known as the net estate or a tarikatu safiyah. And from the net estate, a person is able to give up to 1/3 of their net estate to non-heirs. This is often discussed as charity that one can give to Muslim organizations, Muslim institutions, and that's absolutely one of the options, but you're also allowed to give it to individuals who are not listed as Quranic heirs. This can also include non-Muslims. So after you've given what's known as the wasiyah, the gift, also sometimes called a bequest, you are left with what's known as your residuary estate, and in Arabic this is called al-mirath, and the residuary estate needs to be distributed to Quranic heirs as designated in Surah An-Nisa, and this is what we call al-fara'id, the fixed Quranic shares. So that's the four-stage distribution of an Islamic estate. The question then is, how do we combine these two systems? If we're living in Canada, how do we work within System 1 while implementing System 2? Now, this is where it gets a little tricky, and this is probably best illustrated with an example. So imagine you have Zaid, and Zaid has a family. He has 2 sons, he has 2 daughters, he's married, and he has a mom and father who are still alive. And he has these assets. He has a car that is owned in his name only. He has some Bitcoin on some exchange, let's say. He co-owns his home with his wife, and he also has a TFSA. Now, how would these assets be treated if Zaid were to pass away? Remember that in Canada, everything that you own after you pass away is split into these 2 asset groups, the frozen assets and flowing assets. So his car and his Bitcoin that he has on an exchange would probably fit in the frozen asset group. They would require a will to be unlocked. And his home, because he co-owns it with his wife in what's known as joint tenancy with right of survivorship, would pass directly to her, and the TFSA would pass directly to whomever he listed as a beneficiary. And the challenge here is that both of these asset groups have to be included in establishing the gross estate, the tarika. And that is somewhat of a challenge because in Canada, these two asset groups have different people who are controlling them. Again, the flowing assets go directly to whoever co-owns that asset or whoever is listed as a beneficiary on that asset with the institution. Frozen assets, on the other hand, are not passed along as easily. Frozen assets need to go through a process called probate that begins with a will that is validated in court, that ultimately leads to a grant of probate to what's known as the executor or personal representative. The executor/personal representative is able then to control whatever frozen assets were left behind by the deceased. So these two groups of assets, which might be controlled by two groups of people, needs to go through the Islamic estate distribution stages. And of course, that would mean that these two groups of people who are in control of the two different asset sets need to work together to accomplish an Islamic estate distribution. So there are a few common approaches here. One common approach is to have one person listed as the executor in the will and have that same person listed as the beneficiary on all of the flowing assets. And this is an option for Zaid. He could have his wife as the executor of his estate, in other words, control the frozen assets, and also have her listed as the beneficiary or the successor holder of his TFSA. And because she already co-owns the home with him in a joint tenancy with right of survivorship setup, she would end up having 100% of the home in her name after his passing. And then she would be responsible for distributing those assets or the value of those assets to the Quranic heirs. The other option is to have multiple people controlling the assets, so to have one executor and then to have another beneficiary or several beneficiaries of flowing assets. Regardless of which approach is taken, some redistribution may be necessary to fulfill the Quranic shares, and cooperation amongst everyone is required. So where does a court fit into all of this? Before I began to study this issue, I was under the impression that the court was very much involved throughout the entire process, and that's actually not the case. The court is most involved early on in the process. That last will and testament needs to go through court in order for it to be validated. And ultimately, the executor needs what's known as a grant of probate so that they can go on and control those frozen assets, those probate assets, and begin to move them in ways that are in line with whatever's laid out in the will. But after that, it's really not involved unless there is conflict. If somebody challenges the actions of the executor, if somebody raises an issue, there's a chance that the court will get involved. And if the court does get involved, then things will probably be very messy. And this is why lawyers have to think very carefully about the work that they're doing. They need to ensure that the documents that they're producing hold up and are defensible in court, and that whatever your wishes are ultimately enforceable by way of the court. Which is why if somebody is reasonably certain that there's going to be conflict or there's going to be tension within the family after one's passing, because perhaps they have a complicated estate, or perhaps they have a very large estate, or perhaps they're uncomfortable talking through some of the specifics of the estate before they pass away, it's a very good idea to get a lawyer involved to ensure that whatever your wishes are ultimately enforceable in court. That said, this can feel very complicated, especially if you're trying to get this done on your own. The question that I wanted to try to solve is, how do we make this easy? How do we give our family the information, the direction, the authorization to do what needs to be done, not so that they're left with a mess, but they're actually left with a legacy? And that's where the Islamic Will Kit comes into play. The Islamic Will Kit is 5 resources that walk you through the 3 steps of the Islamic will and legacy process. The first resource, the first tool, is what's known as the Islamic Will Workbook. The second tool is what's known as the Islamic Will Discussion Guide. And then we have the Last Will Template. These 3 tools help you go through the 3-step Islamic will and legacy plan process. 1, to discover, then to discuss, and then finally to document. And then there are two additional resources. The legacy letter template is a template to help you leave advice to your family, a time-honored Muslim tradition, in the form of a letter. And then there are power of attorney templates for you to grant authority to someone to take care of your affairs and to make decisions on your behalf in case you are incapacitated before your passing. Once those are all filled out, printed, and properly signed, you put them all into a folder that you will call the legacy folder. Now let's go through each of the steps in the Islamic will and legacy plan process. The first is to discover, and you're going to use the Islamic will workbook for this, where you'll list out all of your frozen and flowing assets. You'll list out your debts and determine what your net estate is. You'll list out whatever gifts you want to give to individuals or to institutions and find out what your residuary estate is. And then you'll figure out what the Quranic shares are for your inheritors and see what the value would be of your estate that they would receive. This is sort of simulating what this distribution looks like if you were to die today. That's valuable because it'll give you an opportunity not just to see what it's like, but also to make a decision about maybe moving certain assets to people right now, to give gifts right now, because you have an opportunity right now to move assets in ways that you won't be able to later. Again, you'll be using the Islamic will workbook tool to help you in the discover phase. In the discuss phase, you'll take whatever you've learned in the discover phase and discuss it with your executor, with your beneficiaries, with your Quranic heirs, and make sure that they're all on the same page. You can be as specific or as general as you deem fit, but we have a Islamic will discussion guide to help you through that process. That's the second tool in the Muslim Money Will Kit. And then the third step is you're going to document by filling, printing, and properly signing your last will. This is going to be you taking information from the workbook and putting it into the last will and testament template, and then making sure that after you print it, you properly sign it in blue ink to distinguish originals from photocopies. It's important to note here that the reason why a lot of DIY wills get thrown out or get challenged in court is because they're not properly signed and they're not properly witnessed. So it's very important that you follow the directions on signing and witnessing the last will. And then you're going to make sure that you designate the beneficiaries at the institutions that are holding your flowing assets to ensure that whoever you want to have control over those flowing assets are in fact listed on the official documents. A note here about beneficiaries who are under the age of 18. If you have a beneficiary who is receiving assets after you die, who's under the age of 18, they will not be able to take possession of those assets. Instead, they will need to have a trustee take control over those assets while that minor is still under the age of majority. Now, if you do not appoint a trustee, the court will probably appoint a public trustee, and that's probably not something that you want. So you want to make sure that you appoint somebody both in the will. The current will template has the executor set up as the trustee, and also with any institution that's holding your flowing asset, you want to make sure that there is a trustee designated for any flowing assets that are going to a minor beneficiary. Once all of those steps are complete, then you want to print off your Islamic will workbook. You want to print off your last will, make sure that it's properly signed and witnessed and maybe has an affidavit of execution. Place it into your legacy folder like I have here, and then inform your executor and backup executor of the location. This legacy folder ends up being very critical in the what we call phases of final affairs. So in the first 48 hours after your passing, your executor is going to obtain a medical death certificate and arrange for your Islamic burial, and the legacy folder will be instrumental in making sure that any funeral directives that you have are followed. In the second phase, your executor is going to file for an official death certificate and secure assets, freeze assets, and notify institutions. Your legacy folder, because you have listed all of those assets and all of those institutions in the will workbook, will be instrumental in helping the executor fulfill what needs to be done in this phase. In phase 3, when what we call classify and notify, the executor is going to open up an estate account and apply for probate potentially. And again, they'll have to have details of all of your asset ownership, and we'll have several legal documents that they'll need to submit, including your will. That will all be in your legacy folder. In the fourth phase, which we call calculate and plan, your executor will prepare a distribution plan for the heirs and reconcile flowing assets with inheritance plans. And again, your legacy folder will provide all of the financial details and your last simulated distribution plan, which the executor can use as a template. And then in the fifth and final phase, when your executor is selling assets, filing taxes, distributing inheritance, and closing accounts, your legacy folder will be key, not just for those items, but also it'll have your legacy letter, which will be the wisdom that you have left for your family to read and to consider as your executor closes your estate. In each of the phases of the final affairs, your legacy folder is instrumental. And so it's important to have that folder prepared, and the Muslim Money Will Kit is there to help you get that all done. All right, now's the time to break out of the will list cycle. And you can do that by getting access to the Muslim Money Will Kit by going here. Let me know if you have any questions or comments. I'll be sure to respond, inshallah. Assalamu alaikum.